Welcome, everybody. It's wonderful to see so many of you here. Thank you for taking time out of your busy days to participate in this very exciting conversation. My name is Elisa Kaplan, and I'm the Executive Director of Reform for Illinois. Reform for Illinois is a nonpartisan democracy reform organization that advocates for policies that create a more ethical, accountable, and inclusive democracy. I'm really excited about this discussion, which takes on an issue that has become shockingly relevant in recent years. I don't think most of us would have predicted that this question would ever be anything but academic, but given legal proceedings against the presidential candidate who's currently leading in many polls, here we are. I'd like to thank our participants and our co-sponsoring organizations, the American Bar Association's Division for Public Education, the American Constitution Society, Chicago and Austin, Texas chapters, the Federalist Society, Chicago chapter, and Reform for Illinois. The format will be a formal debate followed by a discussion with audience questions. We'll take questions from the audience via the Q&A feature you can see at the bottom of your screen. The program offers continuing legal education credit to Illinois attorneys. Anyone seeking credit should fill out the survey at the end of the event. The question we're debating today is, does the Constitution give the president the power to pardon himself? And even if he can, should he? Each participant will have 15 minutes to make their argument and then 3 minutes for rebuttal. After that, we'll extend the discussion with additional questions. There'll be a timer on the screen, so I will not be giving time's up warnings. It's now my honor to introduce Professors Brian Kalt and Jonathan Turley. Brian Kalt is Professor of Law at Michigan State University. His research focuses on structural constitutional law, especially provisions concerning the presidency and juries. He's written for the Washington Post, the Wall Street Journal, and the Atlantic, among many other publications. His law review article on the impeachment of ex-presidents was cited by both sides' lawyers during the second impeachment of President Trump. Professor Jonathan Turley comes to us from George Washington University. He's a nationally recognized legal scholar who has written extensively in areas ranging from constitutional law to legal theory to tort law. He has served as a consultant on homeland security and constitutional issues and is a frequent witness before the U.S. House and Senate on constitutional and statutory issues. He is also a frequent commentator in the press, and in a recent study was found to be the second most cited law professor in the country. Who was the first?
I believe it was Alan Dershowitz.
Really? Oh, that's interesting. I thought maybe Posner, who authored this study, I guess, right? Or a different one. Jonathan, since you are arguing in favor of the resolution, you get to go first.
Okay, well, thank you very much. That was not me barking. In fact, as I told my host, I'm getting over the flu. So if I break into convulsions of coughing, it's not in response to anything that Professor Kalt has to say. I'm down to my last halls, which I'm saving for an emergency. I want to thank the Reform for Illinois and the American Bar Association, the American Constitution Society, and the Federalist Society for the invitation to debate today. But I'd particularly like to thank Professor Brian Kalt for his excellent scholarship in this area and his agreement to take the other side. This is a longstanding debate that preceded the Trump administration, but it's taken on obviously new implications in light of the pending criminal matters facing the former president. For over 2 decades, I've maintained that a president can grant himself a pardon. I held that position before Trump took office. I also believe that a president can be indicted in office, and the reason is the same. The Constitution prohibits neither a self-pardon nor a presidential indictment. All scholars in good faith first begin with the text of the Constitution. Even those opposing self-pardons acknowledge that the pardon power contained in Article 2, Section 2, Clause 1 is strikingly unlimited in its language. It has some limits, as we're going to talk about. It says that a president is given, quote, the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. While there's some intriguing arguments on the meaning of terms like pardon, the language on its face suggests that this power is bestowed upon a president without limitation, other than extending only to federal offenses and excluding cases of impeachment. There's also general agreement that the constitutional debates themselves are not particularly helpful. There was relatively little discussion of the pardon power, and the issue of self-pardons was not raised in most of these debates. Once again, there are very few exchanges in favor of either side. You have people like Iredell that raised it, but it effectively, the discussion didn't go forward. That leaves us with this debacle, and I think it's a good faith question. This is a close question. I respect people on the other side who believe that a president cannot give a self-pardon. For some of us, the natural default in a circumstance like this remains with the text that absent a stated limitation excluding self-pardons, we presume that no limitation applies. In reaching that conclusion, many of us have stressed that the authority to issue a self-pardon does not mean it's a correct or commendable act. To the contrary, I've criticized self-pardons, including with reference to President Trump. And I've also criticized past uses of the pardons, which included family members and political allies and donors. So we have to sort of deal with the elephant in the room of the former president. There is a habit that there's a tendency that the relevance to former President Trump can have this great gravitational pull and can distort one's view of the law or how one interprets not just the Constitution, but even criminal codes. If one believes that the text allows for self-pardons, there's no exception that applies to Trump or his cases. Likewise, there's no further justification that's required. For the purposes of our discussion, we probably agree on self-pardons being not a good idea, but something that we oppose on policy grounds does not necessarily, and in many cases should not, influence our interpretation of the Constitution. The inclusion of this largely unlimited power to pardon was not a particular surprise to some of us, and this is where I might have some disagreement with Professor Colt, and I've really enjoyed his writings on the area. Academics are divided, as you know. There's almost the same number on both sides that I can see in terms of all the articles written in this field. The British Crown enjoyed what was called a prerogative of pardons, and it carried over to our Constitution with other elements of the British law. British law, as you know, believed that the king could do no wrong. One controversy over this power that came up with Parliament during the tensions with the king was whether the king could stop an impeachment through the use of the pardon power. It's not surprising that the framers focused on that issue to create one of the exceptions to pardon power while leaving the rest. It excluded impeachments. So the great powers given to the British king means that this was not an issue that came up a great deal. Charles I that was executed it did so after the Civil War. Pardon was not considered a particularly useful off-ramp before they offed him literally in his execution. The framers did limit this to federal offenses, meaning that a president could not entirely insulate himself from criminal charges. Indeed, at that time, most criminal laws were prosecuted by the states, not by the federal government. And so this wouldn't have been a sort of complete immunity for a president, and still is not. In fact, the recent cases show that while President Trump could theoretically give himself a pardon on the special counsel's 2 cases in DC and Florida, he could not do so with regard to Manhattan and Atlanta. Now, while the language refers to reprieves, the court has read this pardon power quite broadly, I think for many of these reasons, and that includes extending it to lesser included aspects. For example, commutations to lessen a penalty, or amnesty. And in the cases like Schick and Klein, the court really reflected this very broad view based on that language. And in his treatise, Justice Story concluded that, quote, Congress cannot limit or impose restrictions upon the president's power to pardon. Chief Justice Chase wrote in Klein, quote, to the executive alone is entrusted the power of pardon. It is granted without limit. And in Schick versus Reed, the court ruled that this prerogative is not to be otherwise limited and, quote, ought not to be fettered or embarrassed by anyone else. These pardons are not adjudicative decisions, and this sort of anticipates possibly a point of disagreement that we may have. This is a decision that is made, after all, despite rulings of courts, despite overwhelming evidence of the violation of law. Now, the inclusion of this pardoning power might not have been viewed as so counterintuitive as it is today. Putting aside the British tradition in that issue, and on that reasonable minds can disagree, there were already efforts in the early republic to use courts for what people call lawfare today. I have a book coming out next week on free speech entitled The Indispensable Right, Free Speech in the Age of Rage. And it looks at that, how we began as a country. And the fact is that the Constitution was not just written for times like this. It was written in a time like this. And it was written at a time when there was rising violence against political opponents, but more importantly, the use of laws against political opponents and raw politicalization of the system. And that includes things like the Alien and Sedition Acts that was used against Jeffersonians. Jefferson came into power after that type of weaponization. So for those that view these cases as targeting Trump, there might be a certain degree of analogy to those issues. I just want to note very quickly, because I'm running out of time, that there are 2 things I'd like to anticipate. First is the argument that a self-pardon violates a president's obligations under the Take Care Clause of Article 2 to guarantee the faithful execution of federal law. However, all pardons excuse or prevent such execution. They're not adjudicative actions. They stop the process from someone being punished. And they have been routinely used for incredibly guilty people. Jefferson was accused of using his power to pardon his political allies under Alien and Sedition Acts. He pardoned Bowman, that's Dr. Eric Boldman, to testify against his arch rival, Aaron Burr. Harding and Attorney General Doherty pardoned Lupo the Wolf, who was a hitman, who went back to New York to continue whacking people for the New York mob. Roosevelt, Truman, Harding were all accused of using pardons for their political benefit. And so all of these were interrupting the process of adjudication, the faithful application of laws. The second issue I want to get to is that you can't have the use of the pardon power for so-called self-dealing, that the Constitution reflects a policy against that. And I like this argument because I certainly see the basis in that there's this almost common law or underlying theme that you should not be able to use powers to advance your own interests. But the fact is the presidents do that all the time. They do that obviously in these examples of pardons, but they also use it to benefit their family. Bill Clinton was a serial abuser of pardon authority and used it to benefit family, friends, and political donors, including his own brother, Roger Clinton, Susan McDougal, who could have testified against him. He pardoned Mark Rich, who may be the least compelling recipient of a pardon after the Wolf, but he was a major donor. So there is the use of powers occasionally, excuse me, for self-dealing. And the Constitution certainly can reflect a value without necessarily imposing a limitation. And I certainly agree that that's why self-pardons should be disfavored. But the assumption is that people who engage in abuses of powers will be held accountable politically. That's the reason Clinton waited until the last day to pardon his family. It's also President Trump issued pardons that I heavily criticized in his final days. There's a certain, pattern to that, and you can be held accountable politically. You can also be held criminally accountable under the state laws that are a mirror image in many respects to the federal law. So in United States versus Wilson, Chief Justice Marshall described a pardon as, quote, private though official act of an executive magistrate. He also described it as an act of grace. I like that quote because in some ways it combines the views of myself and Professor Cole. I understand the point and I appreciate the point that Brian is making, that when we talk about an act of grace and we talk about the word pardon, that usually brings up this connotation of one person giving someone else a benefit, and indeed a type of act of grace. But it has not been used that way, and it has never been required to be used that way. And indeed, if you say that it's there, that you can't use it to stop the faithful execution of laws or self-dealing, there would be a long list of pardons historically. It would violate that principle. And so what I would end with is that, like many powers in the Constitution, this one can be abused, but some powers are left to citizens to mete out their own judgment on those who abuse them. I believe this is one of those powers. And I'll stop there. 1 minute left of my time as an inspiration to Brian. But thank you very much.
All right. Well, thank you, Jonathan, and thank you to the hosts of this wonderful event. I'm glad to have the opportunity to engage in, as the program calls it, civil disagreement. One of the major themes of my work, going back to 1996, which is when I first wrote about self-pardons, is that it's really important to think about things like this well in advance of an actual case arising. When I was writing in 1996, I wrote the strongest case that I could muster against self-pardonability. More recently, in 2012, I had a chapter in my book, Constitutional Cliffhangers, about self-pardons. And in keeping with the theme of the book, I gave both sides of the argument. I didn't pick sides. I still believe in the wisdom of sussing out these questions when they're still abstract. But of course, this issue ceased to be abstract in 2017, when then President Trump first started talking about pardoning himself. The thing is, if you had surveyed people about this question in 1996, you would have gotten a division of opinion, but it wouldn't have followed party lines. And I'm very confident that if you surveyed people now, there would be a heavy partisan skew. I think that's a problem for the rule of law. The Constitution says what it says, as Professor Turley said, the same for presidents we like as for presidents we don't. So as hard as it may be to do so, I urge people on both sides, when thinking about this question, to ask themselves not just how they would feel about Donald Trump pardoning himself, but how they would feel about it if the partisan tables were turned. I also appreciate Professor Turley noting that this is a close question. A lot of the commentary that you hear, and I think the nature of the media is sort of set up to favor this, makes it sound like there's a definitive answer. There is no definitive answer. That's why we're here today. Be suspicious of anyone talking about a question as unsettled as this who claims that the Constitution gives us only one answer. Like so many other constitutional provisions, this is like Schrodinger's cat. Until and unless the courts review this question and settle it, the president may or may not have the power to self-pardon. Every argument that I'm going to make today has a response to it. Every argument Professor Turley made has a response to it as well. That's the nature of constitutional law. So again, I'm not here to say that there's no debate. I'm here to say why I think that a judge reviewing this question should rule against the validity of self-pardons. If God forbid I was ever a judge and I got this case, that's how I would rule. As I've been saying again for almost 30 years now, the argument against self-pardons makes more sense legally, fits better with the structure of our constitutional republic, and I would argue is consistent with the text and the history. I'd like to start with the history because it is true that the framers didn't talk about self-pardons, but they did talk about pardons, and they did so in a way that I think shed some light on what they would have thought about self-pardons. I think that they didn't mention self-pardons because, I submit to you, it wouldn't have occurred to them that such a thing would be possible or acceptable. The passage in the convention debates that is most significant here is when Edmund Randolph was arguing that presidents shouldn't be entrusted with the pardon power in cases of treason. And this was hearkening back to the case Professor Turley mentioned of Charles II and the Earl of Danby. Charles II had Danby do all of these things. The king was untouchable legally, but Danby wasn't, and so Parliament was going after him. And so the king pardoned him. And so Randolph was sort of evoking that when he said, we should restrict the pardon power in cases of treason. He said, quote, "The president may himself be guilty. The traitors may be his own instruments," unquote. And this was a problem. What to do about a president run amok? And what sort of presidency were we creating here? Some in the convention at that point suggested that the dangers like these were best handled by transferring the pardon power away from the president to Congress. But James Wilson, later Supreme Court Justice Wilson, responded that the power to pardon, including in cases of treason, should stay with the president despite the potential for abuse. And the reason for this was he highlighted the distinction between the Constitution that the convention was creating and the King Charles episode. He said, if the president be himself a party to the guilt, he can be impeached and prosecuted. And the implication being, and a king couldn't be. You can't go after the king. You can go after the president. You can prosecute the president. So, okay, he can pardon his cronies, but you can prosecute him. And Wilson's view carried the day. Randolph's motion failed. And so I submit to you, if the delegates thought that self-pardons were okay, Wilson's argument would not have been very persuasive. He would have been saying, well, you can, if the president does that, you could prosecute him if he doesn't deign to pardon himself. He would show self-restraint and repentance and a willingness to suffer a penalty for his treason, one of the few federal crimes at the time, suffer the penalty even though he had the power to avoid it. If this was what Wilson meant, it seems doubtful that his argument would have passed unrefuted, let alone that it would have carried the day. So again, I submit to you, that's not what Wilson meant. I do think that he believed and that the assemblage believed that presidents could not pardon themselves. Now, to some of you, it matters a lot what the framers, if asked, would have said about this. Others of you are not as much. And I would like to engage the textual argument. And the argument for self-pardonability has the great benefit of simplicity. The president can do this because the Constitution doesn't explicitly say that he can't. And I don't think that's quite right for a couple of reasons. The notion that the pardon power is unlimited, other than these specific exceptions. There's a lot of Supreme Court case law on this where they're talking about the unlimited nature. They're generally referring to the ability of Congress to restrict the power, but that doesn't tell us what the full bounds of the power is itself. There's another important part of the pardon power that I think offers a wonderful analogy here. You can't pardon someone for something they haven't done yet, right? You can't give someone a pardon in advance. And this is not specified anywhere in the Constitution, right? But it's part of the definition of a pardon. So yes, the power is broad. Yes, there are not explicit limits here, but you can't do it. And the courts recognize you can't do it, because if you tried to do that, it wouldn't be a pardon. You could call it a pardon, but it wouldn't be a pardon. And my argument is a self-pardon would not be a pardon either. Looking at the definition of a pardon, it is, I would argue, inherently bilateral. An act of grace. Grace, the Oxford English Dictionary, defines that as favor on the part of a superior, right? This is something visited on an inferior by his superior. A pardon also traces to the Latin perdonare. The root of that, donare, is the root of two other verbs, condone and donate. And I would say the same thing for those. Linguistically, you can't condone your own actions. That doesn't make sense. You can't donate to yourself. It doesn't make sense. By the same token, from the same root, you can't pardon yourself. The Constitution also speaks of granting a pardon, and the Oxford English Dictionary defines a grant in law as to transfer from oneself to another person. So again, it's inherently bilateral by definition. So the language, the limit is there in the text. And there are other similar implicit limits in the Constitution. They aren't there explicitly, but it just wouldn't make sense otherwise. You can't declare war in a civil war. It's clearly a war. The Civil War was clearly a war, but there were no declarations by either side because they recognized that it wouldn't have made sense. Similarly, saying that there are limits expressed, right? No impeachment pardons, no state pardons. That expressio unius canon of construction tells us that there must not be any other limits. There are other limits, and they can come from elsewhere in the Constitution. And I make an analogy in my article to the Elections Clause. The Elections Clause gives Congress the power to regulate the times, places, and manner of electing senators and representatives, except as to the place of choosing senators. So does that mean that they could do whatever they want as long as it's not about the place of choosing senators? Could they say that House elections have to be in Nome, Alaska, and the manner is you have to vote in person? Presumably not. Courts have rejected that expressio unius reading of the Elections Clause. They've detected implicit laws on Congress's power there. And I would argue there are similar implicit limits on presidential power dating or being tied to the constitutional construction, the structure of the presidency, of the rule of law, and other principles that I'll conclude with. A similar example, and maybe this won't convince anyone, but it tells you what you're accepting if you accept self-pardons. The vice president presides over the Senate, with the exception of when the president is being tried in an impeachment case. So what does that mean if the vice president is impeached and put on trial? Does that mean that the vice president presides over her own impeachment trial? If we look at the Constitution, just looking at the clauses, not looking at the broader context, the broader principles, then yeah, maybe she would. I submit that that wouldn't make sense either. So these structural principles I mentioned, what are they? One of them is relating to the structure of the criminal justice system. In order for you to suffer criminal consequences, a prosecutor has to prosecute you. In the federal system, a grand jury has to indict you. The trial judge has to let the case go forward. The trial jury has to convict you. The appellate judges have to uphold the conviction. And the president has to not pardon you. And at every other stage in that process, we do not let people work on their own case. The prosecutor can't be the prosecutor in his own case. The grand jurors can't be grand jurors in their own case. The trial judge can't be the trial judge in his own case. And the Supreme Court has recognized this principle. The trial jury can't be a juror in your own case. The Supreme Court has recognized this principle. Now, the issue here is that who would have standing, right? If a judge has a financial interest in a case, then the criminal defendant can say there's a due process violation. You don't have standing, and anyone have standing to make that same argument here, but the principle still applies. If you want the benefit of one of these ducks in the criminal justice system not being in the row so that you can't suffer these criminal consequences, then you need for someone other than you to be the one to make that decision. No one can be the judge in his own case. And I take the point that this isn't an adjudication, but it does have the effect of deciding what the criminal consequences in a case will be. And again, we don't let people do that in their own case. There's also the notion of a limited presidency. Presidents are not kings. This would present impunity. Maybe we can have another debate about whether presidents are immune from prosecution while in office. Something else I've written about, and I cited Professor Turley in that work as well. But if the president is immune from prosecution while in office, then a self-pardon wouldn't really come up while he's in office. If the president's not immune while in office, then he might as well be, because if he can pardon himself, because then he would just pardon himself, at least from federal crimes. Everyone can escape criminal consequences if the president agrees to pardon them. So again, it's not like we're saying the president is a king because he can pardon people. Of course he can pardon people. But can he pardon himself? That would make the president too much like a king to fit comfortably within the structure of the limited presidency that we have in the Constitution. I'd like to conclude by noting something that I said in my 2012 book chapter. I wrote about the prospect of a president pardoning himself on his way out of office. And I said, I had a footnote, I said, it's theoretically possible that a president could pardon himself for things he did before while president, but it's hard to imagine that someone would come into office with something to pardon, with a conviction or an ongoing case. And that was in 2012. I guess things have gotten more imaginable to me now than they were back then. But with that, I did take my full 30 minutes, but I yield back to Professor Turley.
I thank you, Brian, and I really appreciated your arguments on this. I think as usual, they're very compelling in many respects. I don't ultimately agree, but not because your arguments don't hold together well. They hold together quite well. But I think that we are really at an impasse in some respects once we get to the text and once we get to the ultimate conclusion. If I were a judge, and God forbid, to use your language, that would be the case, I would not hesitate to say that a president can engage in a self-pardon. I just want to note a couple of quick things, and these are just small disagreements. One of them is not much of a disagreement as just an interpretive issue. I agree with Brian that the Wilson comment is a strong piece to use, probably the only really compelling piece in my view from the debates that can be used for against self-pardons. But the problem with that debate is it was really tied up with the issue of treason, whether you should eliminate treason or whether treason should be incorporated. It's really hard to, I think it's a bit of a stretch to say that Wilson's view prevailed necessarily on the issue of the presidency. One of the problems that we have is that many of the framers probably considered it unimaginable that a president would in fact engage in some of these acts. And I think that many of them probably took it from that perspective. On the text, the fact is that what Brian was talking about the text, it is true that other aspects of the Constitution obviously are interpreted because they have terms subject to how it's executed that have to be interpreted. The court is actually, the pardon cases are pretty different. I think Brian would probably agree with this, in that when the court has dealt with it, it has tended to treat it as this broad, unlimited power. And that includes, by the way, in reference to what Brian said, yeah, you can't pardon someone in advance of a crime, but you can pardon them in advance before any conviction or indictment. So you had Ford and Nixon. With Nixon, there was a case in that. Carter was a case of that, where you could pardon people before they were ever even indicted. And that was in part because of the broad interpretation that the courts have given to this issue. And when Brian says, look, this would make kings of presidents, I don't think that's true. I certainly understand that this would bring a president closer in the use of this prerogative, as it's called. In fact, it was used quite broadly by British kings. But our pardon power excludes impeachments, but also excludes state offenses. And that includes where most of the criminal laws resided back then, and still today, presidents, as we've seen, can be prosecuted. So I don't believe that is as compelling a point.
Well, I take your point, and I think that they were discussing treason in part because it was one of the few federal crimes. I think that treason mattered a lot to them, and if they were comfortable with the idea of a president pardoning all of his treasonous co-conspirators, that comfort, again, reflects, it doesn't state, but it reflects an understanding that a self-pardon must not be possible, that at least you could go after the president, right? You could impeach him. Well, if the president can pardon himself, that gives the president a level of impunity and a lack of accountability, particularly back before there were term limits. The president would be able to do all sorts of things to get reelected, perhaps to interfere with Congress to prevent the impeachment. Some of this runs into the questions about presidential immunity. I do want to, maybe I shouldn't use my time to argue against myself, but I do want to say,
please do.
Professor Turley mentioned the argument about the president taking care that the laws be faithfully executed. Professor Sugarman has written about that. I don't buy that argument either, for the reasons you said, that by that reasoning, almost any pardon could be seen as a violation. I think it's more about, again, the structure of the presidency as limited, that the kings couldn't pardon themselves because they didn't have to. Why give a president more power than a king had? Why give the president the level of impunity that a king would have? Everything else about the pardon power is giving presidents the power to pardon everyone else that kings had. Giving them the power to pardon themselves was really the only thing that would separate presidents from kings at this point, at that point in the drafting process. As far as the case law, what the court has said about it, again, they've said that it's broad, usually talking about Congress not being able to limit it, but that doesn't mean that presidents can do whatever they want. It has to be a pardon. And so if granting a pardon is an inherently bilateral thing, then it doesn't matter how broad the rest of the power that the president actually has is. It's not a pardon to do that any more than it would be for the president to issue a letter of marque and reprisal and call it a pardon, or something else. If it's not a pardon, it's not a pardon. This time I did finish early, so let's stop there.
Thank you both. I'm going to move to the Q&A now. And I see one or two people have their hands up. If the people who have their hands up could instead write their questions in the Q&A, that would be appreciated. And please, anybody who has thoughts or questions, please drop them in the Q&A. The first question is, would it be helpful if a referral to the Justice Department for their recommendations were made mandatory?
You want to start, Brian, or?
Yeah, I'm not sure if the question is saying should the Office of the Pardon Attorney in the Department of Justice have to sign off on pardons. I think there are good reasons for the president to rely on the Office of the Pardon Attorney. I'm personally uncomfortable with limiting the president that way. Some states do that. They have a board instead of the governor. I think that would be, it would certainly solve the problem of self-pardons, but I think that would be not a proportionate response. There are better ways to fix it than that, interpretive ways, instead of restricting the rest of the president's power.
Yeah, I would add that I think that, and this brings us back, all roads leading back to Rome, that any legislative effort to restrict the pardon is going to run into this issue and actually could force a review, because I think Brian's right. One of the issues with a self-pardon is who's going to have standing to challenge it. If they actually had a law like that, you could conceivably have a better shot at it. But I think that if it was a mandatory requirement limiting the president's ability to use the pardon, it would run afoul of the constitutional language. There is something about pardons that is different. If you look at everything from the British Crown all the way through today, this idea that they wanted to allow someone to make this decision in a non-objugatory fashion, they understood that this would involve issues other than guilt. The person could be entirely guilty, and in fact, many of them are. But they wanted to give this power to the executive. And so doing this by committee sort of runs against that grain, even if it's with subordinates weighing in. But I think it would run into constitutional challenges.
I agree. I think it would require an amendment.
Okay, the next question we have is, do the same principles arguing against self-pardon apply to a president instructing the Justice Department to withdraw pending federal charges once assuming office?
I think that there are a lot of tricky issues about the president, the Department of Justice prosecuting the president while he's in office. And again, that runs into questions about immunity. I don't think that it would be unconstitutional in the same way. And there are a couple of reasons. One, if there are pending charges under Rule 48, they can't just withdraw them. The court has to give, it's by leave of the court. So the court would have to allow that. So if the president said, well, I'm pardoning myself, and so you have to remove the charges because of that, the court wouldn't have to accept that, and the court would have to decide, are self-pardons valid or not. Pardons, of course, are permanent. If it's just withdrawing the charges, that might leave the possibility of subsequent charges after the president leaves office. Maybe they're saying, we're withdrawing the charges because you can't prosecute an incumbent. Maybe that tolls the statute of limitations. Even if it doesn't, it could give rise to other prosecution later. So I don't have the same constitutional problems with that because of those safeguards.
Yeah, this one's pretty wicked in terms of how it would play out. And as you might imagine, many of us have been toying with this scenario for obvious reasons. Because the expectation is that Jack Smith is not going to get to trial before the election. That seems likely, not necessarily certain. So then the question is, if Donald Trump is elected, could he, instead of giving himself a self-pardon, because I think if he gives himself a self-pardon, then the case would collapse. That is, I think most courts would say it will dismiss this because it's subject to a pardon. But the question I took from the person was that, what if you don't have a self-pardon? Instead of, if Trump goes and says, I'm now president, you're my attorney general, stop this because the election in part was on the weaponization of the criminal justice system, and the public has spoken, and we want an end to this, right? And that'll be the sort of rationale. And the attorney general then cuts off the special counsel and then sends in someone to kill the cases. I think that would be constitutional. I think that he would have that authority. It would also be highly controversial, right? And that type of thing can also be the subject of an impeachment if Congress believes that it's an abuse of a power. But I think it would be constitutional. But the reason this gets really super wicked, if I don't know if there's a category for super wicked above wicked, but if there is, this would fit. Because one of the things that I've sort of wondered is, let's say that Trump and Smith go toe to toe after the election, and the new attorney general tells Smith, "You're fired," right? And we're getting rid of this case. What if Smith refused to go quietly into that night, went back to the court, said that this is a usurpation of power? The question is what standing Smith has at that point, because he would not be a special counsel. So this could get extremely weird. But at the end of the day, I think that the president would prevail, is my guess.
The next question is, assuming that a president can self-pardon, what are some of the safeguards that our system has in place to prevent potential abuse and hold the president accountable for potential actions?
Jonathan, you want to take this one first?
Oh, sure. I was going to let you go. Well, the most obvious is that you can have the power to do something, but that something can still be an impeachable offense. Now, I'm not referring to that necessarily as in terms of Trump, but generally, you can abuse constitutional powers. I testified in the Clinton, Trump, and the Biden impeachment proceedings, and I've maintained in all three that you don't have to have a crime to have an impeachable offense. It's something that Alan Dershowitz and I have long disagreed on. You can have an abuse of office. With pardons, it's sort of tough because particularly this reason I separated from Trump, because he'll be able to cite the election in some respects as a sort of judgment upon these cases. But I think that you could see, like, for example, when you look at my favorite Lupo the Wolf, that was an absolutely horrible case. I mean, it involved a really corrupt attorney general, and this was a deal with the New York mob. And he went back and started killing people. And could if the president facilitated something like that, could it be impeachable offense? I would say, yeah, I think it probably could.
I would say, first and foremost, that the fact that this is an election issue, President Trump has talked about pardoning the January 6th defendants if elected. Implicit in that is that he's one of them. And so if he gets elected, that does take away one of the arguments against a self-pardon that you would make if the president was issuing that self-pardon while slinking out of office after losing an election. So the flip side of that, though, is that, again, the voters provide that accountability. And that works both ways. I want to suggest not only might a self-pardon be an impeachable offense, just like any abusive pardon might be, I want to suggest that it might also give rise to criminal liability in certain circumstances. Now, a pardon itself, and the Supreme Court is going to be telling us soon what the limits of presidential immunity for official acts are. But I don't think there's any question that, let's say the president pardoned someone in exchange for $1 million bribe. The pardon could very well still be valid in that instance. The president has the power to pardon. The bribe is still a crime. And so having a pardon potentially be criminal, right, give rise to criminal prosecution, I think that could happen with a self-pardon too. If it's part of a criminal conspiracy, then that can do a few things. It's another overt act for the conspiracy. It might extend the statute of limitations because you can only pardon yourself for things you've already done. You can't pardon yourself for pardoning yourself. I mean, I guess you could try, but eventually you'd run out of time. And so I think there is a possible criminal limitation on that. There's also, as has been mentioned in a couple of times, a couple of ways, the potential for state prosecution as well. Impeachment, elections, and possibly criminal liability.
Yeah, if I could add something, Brian, on that. The one is actually a point that I wanted to get in, but I cut for time, which is it sort of goes against the idea of against self-pardons, because you can have something like a Carter sort of amnesty type of pardon that benefits a president. And January 6th is an example of that. Trump could come in and say, look, I just think that was a protest that became a riot, and there's a lot of excessive prosecutions or whatever he may argue. And I'm going to pardon everyone associated with the January 6th election. The Carter example is an example of where you can make sort of group or broad pardons, and that would also be a pardon that benefits the president. One could imagine that a lot of such hypotheticals where a president could also be a beneficiary, and that to me cuts against the prohibition. On the issue that you raised, Brian, which I think is really interesting, this business about the bribe. I agree with that. I think you're right. The problem, of course, is, and Brian, of course, knows this, is that we have sort of that coming up in pardons, right? You have a lot of these presidents that pardon political donors that gave them a lot of money for their campaigns, but they're not treated as bribes in our system. So I think that usually these are sophisticated enough; they're not sort of Bob Menendez type of "thank you for the gold bars, here's your pardon" type of case.
One of you briefly touched on this when you talked about the difficulty of having standing, who might have standing in a case like this. Is there any chance that this issue could come before the courts?
I think it definitely would. If there were still a prosecutor going after, right, the president isn't calling off the prosecutors. Prosecutor going after the president would say, I'm prosecuting, and the president would say, you can't, I have a pardon. Prosecutor would say that's not valid, that's not a real pardon, and the court would have to decide. So that's the simplest way. The other way it would arise is if some other official was doing something premised on a conviction, if this is post-conviction, say they don't want to let someone vote. In Florida, if you're a convicted felon, you can't vote. And he might say, oh, well, I have a pardon, so I can. And they would say, well, no, you can't. It's at least possible that it would arise that way as well. But there are a lot of ways where it wouldn't be reviewable, and the president could come in, pardon himself, get the prosecutors to drop the case. Rule 48 requires leave of the court. Maybe the judge is sympathetic and says, okay, you can dismiss this, and there would be no one to appeal it, and we wouldn't resolve the issue. It would be effective in that case, but it wouldn't be effective in establishing that that's what the Constitution allows or not. It would just be practically effective, not necessarily legally effective.
Yeah, I think there's a lot to that, what Brian said, although this gets into that wicked area that I talked about earlier, because it is sort of, we could have a sort of rematch on the Saturday Night Massacres under Nixon, because what's interesting about the resignation of Richardson and Ruckelshaus was that they didn't question whether the president could order it. They just refused to carry out that order, right? They just said, I'm not going to do anything unethical, and I think this is really unethical, and so to hell with you, and I resign. And then Bork came in and said, look, we just can't just have everyone resigning, and I'm going to go ahead and take this action. So if it goes to a court, and let's say Smith does not go quietly into that night, I don't see the grounds how a court could side with Smith, but it could end up being the vehicle that Brian talked about, of going up to the court system. I just don't see how ultimately you would prevail on that.
The next question we have is, can you address the policy and political implications of your respective positions regarding, it says self-impeachment, but I'm assuming the intention was self-pardon.
Do you want to go first, Brian, or?
Okay, yeah. So we already touched on this, talking about accountability and the sort of unique position of the president, sort of campaigning on a platform of issuing these pardons. That does offer some legitimacy to the pardons that would otherwise be lacking. I think what that does is it highlights the sort of unusual nature we're in. I wrote a piece sometime back talking about how we progressed from the two-party system to the two-reality system, and the parties entertain different views of the facts in ways that was not the case before. I wrote that in the context of impeachment, but I think the policy and political implications here are the same as pretty much anything else that's happened in the last 8 years, which is half the country will think it's the greatest thing ever, and half the country will think it's the worst thing ever, and never the twain shall meet. What I think that means, though, is that it doesn't really work anymore to say, well, if the president abuses his powers, he can always be impeached. Because what we've seen is that impeachment conviction, anyway, is not really feasible in our two-reality system the way it once was.
Yeah, I think there's much to that. I think that in terms of the implications, I think Brian was right to talk about the divisions in the country. Roughly half this country does view these cases as weaponization of the legal system. And so if Trump prevails in the election, he will argue that he was vindicated on that issue and that he wants to bring an end to this process. I would still be surprised, because many of us would still caution against self-pardons, that he would want to be the first to self-pardon, particularly because the alternative is to simply have the attorney general end the case, and that would have to go to the court and go through the system that Brian and I talked about earlier. In terms of the implications, it's very hard. I talk about this in my book and I'm not plugging the book, but just on the Age of Rage, that while I referred to this as the Age of Rage years ago, I wasn't suggesting that it was the first one. We've had these ages of rage, and the first one that is most important was between Adams and Jefferson, and there were great abuses of the legal system on both sides. How much did that affect us in the long term? We didn't have as much lasting damage. We sort of came out of it. And these periods are like a fever that takes over the body politic. And it's not, we can't take particular pride when we're in that fever on either side. The level of rage is really shocking. I mean, I was doing some of the coverage at the court in Manhattan, and I was really sad to see the two sides and how much everyone hated each other and no one was talking to each other. And but in terms of the legal implications, I think this period will pass. And I'm sort of optimistic that we won't see this unfold.
I could just add one point. There's a peripheral issue to this. Some people say, oh, well, Trump wouldn't pardon himself because pardon is an admission of guilt. Accepting a pardon is an admission of guilt. It's a very common notion that you'll hear people citing the Burdick case for that idea. The Burdick case doesn't establish that. Granting a pardon is not a declaration of guilt. 99% of the time, pardons are for guilty people. But there's nothing to stop the president from saying, I'm giving this person, maybe me, maybe someone else, I'm giving this person this pardon because they aren't guilty. And I have the power to stop it, and that's what I'm going to do. And presidents do that from time to time. We have vindicating pardons, not just forgiving pardons. And so I think any president who pardoned himself would put it in those terms, would say, this case is baloney, and I have the power to use my pardons to end it, and I'm going to do that, like George H.W. Bush did on his way out of office with the Iran-Contra offense.
Yeah, I was going to raise that, Brian, because that's absolutely right, that Iran-Contra really captures everything we've talked about, because it had a clear benefit to Bush. Some of these people could have implicated him in Iran-Contra, and yet his rationale was that he felt that they were being abused by the system, and it was being used to pressure and intimidate the presidency. So I think that really is a great example.
That's a nice segue into what will probably be my last question before we close. Just want to bring it back to basics a little bit and ask the question, if the framers did intend to allow the president to pardon himself, why would they have done that? What would be the rationale? And maybe that touches on the broader question of what the rationale was for granting the power to pardon to begin with. It's not exactly an intuitive power to give to the executive, even though, as you mentioned, it's a long-standing one. So why was it so important to some of the framers to include this power? And what might they have been thinking if they did, in fact, intend to include the president, to allow the president to self-pardon?
Well, I'll lead if you want, or you want to take it, Brian?
No, because I don't think they did. So
Yeah.
you can start.
First of all, just generally with the pardon power, there was a very good reason at that time why they wanted to give this unilateral power to the president, because we didn't have the sort of traditions of judicial ethics, even the tradition of legal ethics. We barely had law schools. The first law school was created 2 years after the first medical school in the United States, probably because we needed someone to sue. But there wasn't, there was no standardized training. Judges didn't have the sort of judicial ethics. Many of them were incredibly unethical, including John Marshall. I mean, the fact that John Marshall actually wrote the opinion in Marbury shocks us today, right? Because he was a participant in the underlying facts, and it's otherworldly, right? So back then, having someone as the ultimate check on abuse very likely made sense. And also, the chief executive was viewed as a sort of a virtuous embodiment, particularly with regard to George Washington. And I think that there was assumption of that. I don't think, and this gets to the second aspect, that many of them thought that much about self-pardons. I think that they didn't think it was very likely. But had they thought about it, there were a lot of abuses going on at that time, and there were attacks on the president that were going on that time between the Jeffersonians and the Federalists were developing. But also remember, we talked about Wilson. The Fort Wilson attack in Philadelphia, which I'm writing about, the book I'm writing now is about that. That occurred right before the Constitution was approved. And that shows the level of sort of craziness that existed. So the idea of giving one person the sort of check and have a sort of noble party to look and correct these abuses, I think would have appealed to them at that time.
And I agree that there was a sense that the president would be someone virtuous. At the same time, though, going back to that debate, they were saying, what if he's not, right? Like that was on the radar screen too. What if the president is leading a band of traitors? What do we do then? And so why give him the self-pardon then? Again, I think that's why they didn't think they were giving him a power to self-pardon. But why do it? I don't know. Keep things simple. Keep the power broad rather than get into the minutia. There were not a lot of details about a lot of presidential powers. When would the president veto things? Would the president veto things for policy reasons or only for constitutional reasons? That's a whole other debate that they had. They left it by and large to the electorate. That's why I think accountability is so important. And what that means, though, is that when you find things that subvert that accountability, you have to be very careful in reading too much into it. So if pardons did work for impeachments, then there would be no accountability. There'd be no way to stop a president who's abusing his power. So it's very important to carve that out and say, okay, you can still impeach people, whether the president's pardoned them or not. That's very important. Same thing. If you can use the pardon power in ways that make you unaccountable, that doesn't really fit. Doesn't really fit. I think that's where the limits have to be.
I think that's a great place to close. I want to thank Brian Calton, Jonathan Turley for this really wonderful in-depth discussion. I'm sure we all learned a lot and are bringing a lot to think about to the rest of our day. I want to thank all the organizations that made this program possible and thank everybody here for attending and participating and asking incisive questions. I want to remind people to complete the survey that you hopefully have a link to. If you're in Illinois and want CLE credit, fill out the survey or look out for a follow-up email later this week. And please watch for our next civil disagreements programs. These programs are aimed at accomplishing exactly what we did today, taking an issue that's become divisive and having an in-depth civil friendly discussion about them. We've had a number of terrific panels and debates, and we will continue that tradition. So thank you everyone again, and we hope to see you next time.
Thank you.